I don't have any questions for this witness, Sheriff.
All right, very good. You may step down. Thank you, sir.
I have no other witnesses, Your Honor. I move to bind over on the charge of great bodily harm and felonious assault.
Response.
So part of the reason why I asked, Your Honor, if you needed, or if it would be helpful to view a more zoomed in picture of this event was because I don't know to what extent a person can illegally try to hold a person in a spot, because what the proofs were did not rise to the level of a felony. And as your Honor knows, the only way that a citizen can make a citizen's arrest or keep somebody in a place they don't want to be is if they've committed a felony in their presence. There was no felony committed, at least before the purported use of the car or the misuse of the car. So you have a situation where even in the video, you can hear, for purposes of the exam, I'll say my client is yelling about, get away from my car. Why are you at my car? He is observed trying to leave. The complainant, and I don't think his wife, I think it was just the complainant, physically stops him from trying to leave a couple different times. And then that's when you see my client drive away. Now, if you zoom in closer, I don't think that this swerve that the first witness testified to is that purposeful. What you see is the car back straight out and then drive forward and straighten out as they're going toward the main road. There's no reason, if my client was trying to actually run this guy over, as it was characterized as, that he couldn't have just done it. If he was trying to turn the wheel, he just turned the wheel and he would have ran him over. Also, the lack of injury, as you know, for GBH cases, an injury is not required, but an injury can be used to show the defendant's intent to do the specific type of harm, specifically the great bodily portion. But on the flip side of that, if there's no injury and the witnesses testified that my client backed out and the complainant is right behind him, which of course he could have just injured him then, there's no injury. And then there's no injury even after the fact with the driving forward. I would submit to the court that that's proof of a lack of intent to do great bodily. And the last thing I want to say is I've been analogizing this situation to a woman leaves the gym and a person or man wants to get this woman's phone number, and the woman shows that she's not interested. And she's walking to her car. The gentleman follows her to her car and then attempts to not let her leave, standing in front of her, behind the car, standing in front of the car. I don't know to what extent the woman has to stay there, or if she decides to floor it. If the gentleman who's trying to keep her in one spot is in front of the car and she tries to floor it and he has to jump out the way, I don't think that constitutes a crime. And I think from the video, from the complaining witnesses, or the witnesses' testimony, I think that's pretty much what we have here. Insofar as somebody trying to hold somebody at a place they don't want to be without any type of legal basis to do that. And you see that person repeatedly yell about trying to leave, yell about being stopped, and then you see them try to get away. So I don't think that rises to the level of a GBH. I think this could have been charged differently, but I think that a GBH is a stretch for these specific facts and circumstances, Judge.
Response.
So the video may have been somewhat ambiguous because it is pretty far away, but the testimony of the witness said that the car swerved to the right where we were not in the parking area, but in the parking space yet, to have to go into the parking space, and actually struck the man and knocked him down. He got hit by a car, aimed at him. I think if you hit someone intentionally, that at least we have GBH. And then FA is, of course, a lesser offense, not included, but just using the car. We just have a road rage type of activity here that began before. We had the spitting in the face, being upset because the police were being called over that incident, and then quickly driving away. People think that makes the element in the video and through the testimony of great bodily harm. And then identifying the defendant, I think we have enough for probable cause to believe he's the one who did this. So I would move to bind over as I've asked. Thank you, Your Honor.
Court, having heard the testimony in this case, what is clear, sir, we can clarify the court's view of the video. While the video, there is a block to it, I think the critical part, coupled with Miss Youngling's testimony, is that it may be indeed a question of fact as to the swerve. Irrespective of that, what is clear is that that vehicle is clearly on the right side of that lane, to the extent that then the individual, Mr. West, is identified by his wife, had to leap out of the way, and you hear his exclamation. So while it might be true that frankly, I don't buy defense their picture of what happened with the people.
Key legal lesson: payment can equal acceptance. If the tenant paid the lower rent, a binding contract might form, even if the landlord erred. Document everything. Silence and inaction cut both ways.
Backed up. What happened when the vehicle backed up? Had it wanted to straight and avoid the individuals that were in that lane, including Mr. West, it could have backed up further, headed on a different angle, and gotten itself out going down that left side. And that's the part that the court is really focused on. That vehicle stays to the right side of that lane where Mr. West is. And then you see Mr. West, as you see in the pole, you see him kind of go back toward the car. And that video from this court standpoint carries great weight as to what that vehicle was doing, what the defendant is identified as the person at the scene. And there is at least enough evidence for the court to believe that the defendant was indeed the one that was driving that vehicle. It's clear to the court that the people have sustained their burden in this case of the necessary elements as to both offenses in this case, both the assault with intent to create great bodily harm less than murder, as well as the other offense of felonious assault. It is, I will address it, but I don't think that it's absolutely necessary on this court's part. I don't think an individual where there is some type of altercation, remembering that the spitting in his face and what's occurring between these individuals has occurred prior to the point in time that he is now calling the police, asking for basically asking for some type of police assistance, but then also requesting and standing where he's standing to have this individual wait. I don't think that was any type of false imprisonment. I don't think it was anything other than Mr. West attempting to try to get this individual to stay there until the police left. And really has no bearing on or any effect on the rights of the defendant in this case, because he actually did leave. He was free to leave. He did leave in the case. And again, I don't think it has any bearing on that. I would also note that I do find the testimony of Miss Yulin very credible in terms of what she saw. I don't think she was attempting to try to exaggerate things, but also she was testifying in essence about two events that occurred that night that involved, well, really three, but two specifically would have involved her husband being hurt. So certainly, and I don't say this with any disrespect, that there was some emotion involved in that, but also the spitting on his face as she's observing it. She's testifying about that. So the court would find, based upon all of that, taking all of the evidence into consideration, that the people have indeed sustained their burden and would bind the defendant over to stand trial on the account of assault with intent to do great bodily harm less than murder, as well as assault with intent or assault with a dangerous weapon, the felonious assault. I just want to be clear, while they're not the same, the felonious assault and the assault with intent to do great bodily harm less than murder, Mr. Prosecutor, are those all the events that occur in the parking lot itself?
Yes, Your Honor. That's the alternate, depending on what the fact finder decides, alternate results that it's available. FA is not a necessarily lesser included, so.
Exactly. Okay, I just wanted to make sure it didn't include a separate event that was testified to regarding the vehicle coming at Mr. West at another location during that night.
No, Your Honor, it is the same.
That same incident.
Yes.
Okay, so I will bind the defendant over. The people have sustained their burden on that. I will also bind the defendant over on an additional charge of assault with a dangerous weapon. That being the event that occurs in front of the store that Ms. Lynn testified to, where the vehicle approached and that Mr. West had to extend his hand. So I will add that count 3 of that felony. I will also add a count 4 of assault and battery, the simple misdemeanor for the spitting in the face of Mr. West. So therefore, the defendant is bound over to stand trial on counts 1 and 2 as stated in the original complaint, as well as count 3, which the court is adding, of another felonious assault, specifically with reference to the initial event. And then also a misdemeanor charge of assault and battery for the spitting in the face of Mr. West. So defendant is bound over to stand trial on all those charges.
If we do the arraignment here, correct?
Yes, that is correct, counsel.
So we would waive formal reading to the extent Your Honor has not already read it formally in the standing.
All right. Defendant having waived formal reading, standing mute, the court will enter a not guilty plea as to all 4 counts. Pretrial in this matter will take place
October 9th at 1:30 with Judge Slay.
October 9th, 2025, 1:30 before Judge Slay.
And here's where things take a lighter turn. Even the judge can't help but joke when emotions run high. Humor like this diffuses tension and reminds everyone court isn't always cold and cruel.
Is there anything as to bond in this?
Yes, Judge.
Go ahead.
So obviously my client is here and in custody. And the last time we were in front of you, he was not. And I think that Your Honor probably is aware of the factual allegation as it relates to why Your Honor wanted to address bond. A couple of things though. I was a little confused about the court's instructions, not because of anything your staff did, but I had never seen a person be expected to report to jail without a specific order. But regardless of what I saw, when I explained the situation to my client and explained like, hey, you may want to report earlier than Tuesday, he was more than willing to do that. And I can't say that would have been the case in most clients I have, honestly. So I think that counts for something insofar as he's willing to come to court when Your Honor doesn't even explicitly say it, but it's expected for him to come to court. So I think that goes in his favor. The other 2 more important things though about bond, Judge, is that my client, I think Your Honor is familiar with him from past cases. he receives services through this county. One of those services is the use of a support dog. There is no one else to care for this dog while my client is in custody. My client is, of course I have pictures I can show the court. I think that you are willing to take my word for it, that his relationship with his dog is probably one of the most important relationships that he has with any being on this planet. The second thing that is also important and relevant to bond judge is that he also receives a housing voucher, and he will be disqualified from receiving that voucher if he is in custody for more than 30 days. So with those three things, but primarily two things being in mind, I would ask that Your Honor not necessarily revoke his bond outright, but consider a progressive sanction, and that being tether with house arrest or some type of restricted hours, so that he can still take care of responsibilities, but may not necessarily be allowed to go and come and go freely as he has been allowed to previously. I have not spoken to the complainants or anybody involving the new allegations. But what I've been told is that regardless of what the police agency investigating that does in terms of submitting a warrant request, I've been told that there's not going to be any follow-up with the complainants and that this was actually a misunderstanding. They know my client, and he frequents there often, and he hasn't even been trespassed there, as far as I know. So I would just ask Your Honor to consider those things in relation to bond, and not necessarily just revoking it and put him in remand status until his trial.
I don't need a response. As to the first issue regarding the defendant turning himself in or not, the court had received a bond violation report from the Ann Arbor Police Department. The court reviewed it. The court, based upon that report and based upon the bond conditions that the defendant was under in this particular case, decided to issue a warrant, no bond. There doesn't need to be another order because he was going to be taken in custody one of two ways. I think it was your office and maybe you that called my office to determine what he should do. I don't think any specific direction was given whether or not he should turn himself in. However, there was a valid warrant out for his arrest. Quite frankly, from my position, whether your client had turned himself in or not, or whether he just walked in today, I was going to take care of it. So it really is, from my perspective, 6 of one, half dozen of another as to what he did. Maybe he spent a little bit additional time while in jail. But that's it. But what is clear to me is that the incidents that occur that are at least alleged in the Ann Arbor police report there, that case number being 2540579, which led to the issuance of the warrant that this court issued, show an individual that, frankly, from the court standpoint, can't follow the court's orders, and also would, in this court's mind, be someone who is dangerous to this community. There's not an adequate way in which to control it. While certainly a home confinement tether might be something that the court would consider, I'm not sure that that tether would keep him in. And then once he's out, what it seems to me in looking at these and other, but these particular cases, is that he has some tendency to then engage with people and does engage in behavior where he is attempting to injure, to threaten and or injure people. So I certainly take all of that into consideration in this case. And given all of that, in this case, in the court finding that the defendant has, or at least it appearing that the defendant has indeed violated his bond conditions of this case in an assaultive fashion on an assaulted case, the defendant's bond is hereby ordered revoked at this juncture. So,
Thank you for your consideration, Judge.
thank you, folks.
Appreciate the court's forbearance as I stumbled my way through the.
Pardon?
I appreciate the court's forbearance as I struggled my way through the technology.
No, you did a great job. You did a great job. Better than most I see.
Your Honor.
Thank you, sir. What are they doing? Short man. The court does call the case of the People versus Don Bedoin.
Thank you.
Sorry.
Go ahead. State your appearances, please.
That's for the people?
Hello, Your Honor. Murray Duncan, appearing on behalf of the defendant, Don Boudoin, who's to my right.
I do have before me a plea sheet that indicates that the defendant would be pleading guilty to the charge of disturbing the peace, the 90-day offense. Upon a successful plea to that added count 2, count 1 would be dismissed. There is then an agreement that the prosecutor will recommend probation with a condition being completion of anger management counseling. That is the court's full understanding of the agreement between the parties. Is that correct?
Yes.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your name.
Don Bedoin.
It's this court's understanding that you're going to be pleading guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days of jail and or a $500 fine plus court costs. You understand that?
Yes, Your Honor.
You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yes, Your Honor.
Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will,
Yes, Your Honor.
and also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of May 23rd, 2025, at the location of 2301 North Harris in the city in Ypsilanti, state of Michigan, Superior Township, state of Michigan. What did you do on that date that makes you think that you're guilty?
I got into a heated argument with my daughter where I was yelling very loudly. Some windows were open and I took 2 beer bottles and I threw them on the ground, and a piece of glass cut the top of her foot.
Okay.
And there it is, a rare moment of humor in court. Even the judge couldn't help but laugh. It's these little exchanges that remind us, behind all the legal talk, these are just real people trying to get by.
And you were you in your house, or were you at least exposed to the public area? Is that
Yes.
why
Yes, Your
your
Honor.
windows were open? All right. And you would admit that that behavior disturbed the peace and repose of the immediate area surrounding you?
Yes, Your Honor.
All right. Ma'am, if I do accept your plea, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and the date of your sentencing, that you would not be entitled, that the court would no longer be bound by any sentence evaluation or agreement, and that you could not withdraw your plea. You understand that?
Yes, Your Honor.
All right. Counsel, is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation in the city of Ypsilanti. Sentencing in this matter will be
September 2nd at 10 a.m.
September 2nd, 2025, 10 a.m. That is before Judge Barr at the 14A2 District Court. Bond with its conditions will continue.
Thank you, Judge. Do I just have her contact the court directly for?
Pardon?
Do I have my client contact 14A to directly for?
Yes, yes.
All right.
Contact their probation.
Thank you.
Thank you. Court does call the case of the people versus Christopher Dudley.
Jennifer Douglas for the people.
Assistant Public Defender Hannah Apple appearing on behalf of things approaching now. This way. Will you state your name for the record?
Christopher Nunley.
Thank you. Judge, my client is executing a preliminary waiver at this
He's
time.
waiving on both cases.
On both cases, yes, Judge. And I will state there is an understanding that there will be a resolution involving his parole violation in circuit court, that the prosecutor's office is willing to offer a concurrent sentence. The details of that will be worked out in circuit court, though.
Sir, you're waiving your right to preliminary examination?
Yes.
All right, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that these offenses that are alleged were committed and that you committed them.
Yes.
You understand you will not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, you do, Your Honor.
Preliminary examination having been waived, defendant is bound over to stand trial on, or bound over on counts 1, 2 with 3 following in the case ending in 0699, and on the other matter on count 1 with 2 following.
Your Honor, we acknowledge receipt of the information. My client would stand mute. We waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all 5 counts. Pretrial in these matters will be set for
September 8th at 1:30.
September 8th, 2025, 1:30 before Judge Hammoud.
Thank you. Okay, we'll talk to you later.
Bond will continue.
Thank you, Judge.
Sure. Folks in the prosecutor's office in the 25 F5 5120, I don't have a separate amended or a separate information. I do have the other one though that you can sign off.
I can do it now, right?
All right, fantastic. Thank you. Court calls the case People versus Michael Hill.
For Douglas for the people.
James Fifelski on behalf of Mr. Hill, who is being brought out right now.
Can we up right in all of them because it wasn't up in this one?
Can you state your name, please?
Michael Hill. I have before me a plea form that indicates that the defendant is going to plead to an added count 2 of use of a controlled substance, either being cocaine, ecstasy, or other narcotic, the 1-year offense. Upon a successful plea to that charge, count 1, the possession of a methamphetamine would be dismissed. There is an agreement that a condition of a sentencing will include enrollment and completion of an inpatient substance abuse treatment. And that's the court's full understanding of the agreement of the parties.
That is our understanding as well. I've discussed this with Mr. Hill, and he does want to accept that offer and proceed accordingly.
That's
May I-
his understanding.
Thank you. May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Michael Wayne Hill. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand?
Yes, sir.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind?
Yes, sir.
All right. You signed an advice of rights form, is that correct?
Yes. Yeah.
Any question regarding any of those rights?
No, no, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, I'm not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
and because you believe that you
Another tenant stepping up. You can feel the sincerity. These are the moments that make Judge Simpson's courtroom special. Compassion meets accountability.
are indeed guilty of this offense.
Yes, sir.
August 3rd, 2024, at the location of 3505 South State Street, City of Ann Arbor, Washtenaw County, State of Michigan. Did you have methamphetamine in your possession?
Yes. Yes.
Had you used it?
Yes.
Did you know what you were using was methamphetamine?
No, I thought it was ecstasy.
You thought it was what?
Ecstasy.
Ecstasy?
Yeah.
Oh, same idea. Okay. So you had ecstasy in your possession.
Yes, sir.
You knew you had it
Yes, sir.
and you had used it. Is that correct?
Yes, sir.
All right. Sir, if you commit misconduct as defined by the Michigan court rules between the time of your acceptance of the plea and the time of your sentencing, the court would not be bound by any evaluation of sentencing in this case or any agreement. You understand that?
Yes, sir.
You also understand that you could also not withdraw your plea.
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to the plea in this case?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
September 12th at 8:30.
September 12th, 2025, 8:30 before Judge Perry.
Will Your Honor modify bond to allow him to enter inpatient as soon as a bed
If
is
I'm
available?
presented with an order regarding entry into inpatient, I don't have a problem signing it. I always say it, so I don't need any argument on that. Bond in this matter and all other respects will continue. Thank you.
Good job.
Okay, thank you.
Court does call the case People versus Kimani Hamilton.
National Fellows for the People.
Well, why weren't the plea forms in before now? Yes, no, take Kimani, are they in?
Yes.
Take them back. That one, where's the other one?
So.
I'm gonna have to take time to review them. I can't just do
I
that on the
agree.
fly.
This one is not.
Court does call the case of the People versus Jonathan Hughes, 2 cases.
National Fellows for the People in both matters.
Carolyn Foster Tucker on behalf of Jonathan Hughes in both matters. I believe they just went to go get him. Thank you.
Over here. Go ahead.
Thank you, Your Honor. We have reached a resolution.
I do have a plea form in front of me that indicates that the defendant would be pleading guilty to 2 counts, count 3 of attempted resisting and obstructing a 1-year offense. What is the maximum fine on that, which should be on the form and is not?
Apologize, Your Honor. $1,000.
And also to an added count 4 of use of cocaine, that's a 1-year, $2,000 fine plus court costs. Upon a successful plea, 2 counts 3 and 4, counts 1 and 2 in the case ending in 1056 would be dismissed, as well as case 25F20 or 1040. There is also an understanding that there's no 7411, no delayed or deferred, and the sentencing judge waiver has been signed. That's the court's full understanding of the agreement.
Yes, Your Honor.
Yes, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah,
State your name.
Jonathan Hughes.
Sir, it is this court's understanding that you're going to be pleading to 2 misdemeanor charges. Is that your understanding?
Yes, sir.
Is that your understanding?
Yes, sir.
First of all, that you're going to be pleading to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes, sir.
And also to count 4, use of cocaine. That's also a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
Understanding all of that, do you still wish to plead guilty to these charges?
Yes, sir.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
To the charge of use of cocaine, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. Those are your rights if they are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will.
Yes, sir.
And because you believe that you are would be guilty of these offenses?
Yes, sir.
March 9th, 2023, at the location of North Prospect Street near Holmes Road in Ypsilanti Township, Washtenaw County, State of Michigan. Let's start with, did you have cocaine in your possession?
Yes, sir.
Did you know what you had was cocaine?
Yes, sir.
Had you used it?
Yes, sir.
All right. And then on that same date and at that same location, did you come into contact with police officers from the Washtenaw County Sheriff's Office?
Yes, sir.
Deputies. What happened with regard to your interaction with them?
They attempted to pull me over and I attempted to resist them.
How did you resist them?
By not pulling over.
Okay, so you were attempting to evade their lawful command for you to stop?
Yes, sir.
All right. And you knew that they were police officers acting in their lawful duties?
Yes, sir.
Sir, if I accept your plea in this case, and if between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rule, you would, first of all, not be entitled to withdraw your plea and also would not be entitled to any benefit, or the court would no longer be bound to any evaluation and or assessment of your case. You understand, or agreement regarding your case. You understand that, sir?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Satisfied, Your Honor.
All right. Court will accept the defendant's plea to counts 3 and 4, counts 1 and 2 in case 1056, as well as case 25F2 1040 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
September 12th at 10 a.m.
September 12th, 2025, 10 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you. As to the other two that are ready for a plea, I'm not going to take them right now. I'm going to have to go back and review the police reports, make sure we have all of the elements. What else?
That's all I have.
Everything else is holding other than the next two that I have.
My understanding is Addison is an exam, Carter Price is an exam, and Ms. Gold and Mr. Magoo's files are exams.
Joseph Smith is an exam, and Knight is an exam.
Gee, wonderful job you guys are doing. Oh, joy. All right, let me go take. You may.
Thank you.